नमस्ते, राधे राधे, जय श्री कृष्णा। कैसे हैं आप लोग? यू वॉन्ट टू क्विट अ जॉब बट यू कांट. You think that is because of your employment bond. Are you serious? Are you aware what does court speak about it? Or do you know what are the major important provisions you need to look in your employment bond to make it legally valid and enforceable? No, right? Welcome to my channel. Today we will discuss what Indian courts have stated in their judgment regarding the enforceability of employment bond. What explanation court have given in their clarifications issued in the decisions given by the courts. Now I will tell you what does court is actually speak. So if you are stuck in a job and there is an employment bond, so what are the things that you need to first see? The court has stated in their decision that the terms and conditions should be reasonable. What is reasonable? Like for example, company has imposed a lock-in period of 5 years. That is considered as unreasonable. But company has imposed a 6 months to 2 years lock-in period for you. That is considered as a reasonable. Company is asking for a reasonable compensation. Like they have spent 50,000 rupees on the training of an employee. That is considered as a reasonable. But if they are asking 5 lakhs as a compensation for leaving, that is considered as an unreasonable restrictions. There should be a free consent. The consent of employee should be free from threat, any kind of force. The motive of employer is just to get a compensation for the financial loss that they suffer because of that employee is leaving the organization. So court have clearly stated that the terms and conditions should be reasonable. Like the employer cannot impose any restriction like you can only work in this company, you cannot work in another company. They cannot impose a lifetime restriction also, because that will be considered as a violation of section 27 of Indian Contract Act. Section 27 clearly states that any agreement which restrain you from any trade, profession, from doing any occupation, that will be considered as invalid and void. So if a company puts a condition in an employment bond that employee can only work in this company, he cannot work in any other, that will be a violation of section 27, because it is clearly restricting that employee from working in another company, from doing any profession or a business. One more thing regarding the compensation. Suppose if there is no investment done on the training, on providing any training to employee by the company, but still they are asking for a compensation from that employee for leaving, that is considered as unreasonable. So the motive of the court in giving decision on the enforceability of employment bond is very clear, as it states that all the reasonable conditions can be imposed in an employment bond. If company is making investment on training of an employee, if company is imposing a restriction of 6 months to 2 years, company is giving a confidential business sensitive information to the employee, and company can ask for a reasonable amount of compensation. Only in that scenario where company has made that investment on training of employee. Recently I was reading one of the Delhi High Court judgment regarding enforceability of employment bond. Delhi High Court has clearly stated in that judgment and given a favorable order in favor of employee, because employer was asking a compensation for training of employee where employer has not invested a penny and employer was not able to provide any evidence of investment on the training of employee. So court has given decision in favor of the employee. So I hope this video is very useful to you, very informative to you. Please share this video to more people so they will know whether the enforceability of employment bond is valid in their case or not. It is reasonable or not. अपना वकील खुद बनिए। नमस्ते।